Is that your only case, Mr. Brown?
I think. It's so long.
Court calls the case of the People versus Brandon Nash.
Good morning, Your Honor. Sam Bernstein with on behalf of Mr. Nash. This was Mr. Mayville was just here. Should I go step outside and try to locate?
No, you stay right there, Mr. Jerkus.
Just copy back.
Mayville for the people, Your Honor.
All right, I have before me a plea form that indicates the defendant is going to be pleading no contest to the charge of retail fraud in the second degree. The 1-year offense upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's completely accurate.
That's correct, Your Honor. And I don't know if Mr. Nash, did you say your name for the record?
Brandon Nash.
Thank
Your
you.
Honor. You're welcome.
May I have him?
Raise your right hand. Do you solemnly swear the affirmative testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Brandon Nash.
Sir, it is this court's understanding that you're going to be pleading no contest to the charge of retail fraud in the second degree. That's a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. Do you understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Still wish to plead no contest?
Yes, Your Honor.
Basis for the no contest plea?
Potential civil liability, Your Honor.
And sir, to the charge of retail fraud second degree, how do you plead?
No contest.
You understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as other rights contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yes, Your Honor.
All right. Were you on probation at the time of this offense?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor. and
of your own free will.
Yes, Your Honor.
Court has been provided Pittsfield Township Department of Public Safety report for their case number 254132. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, the court would no longer be bound by any sentence evaluation and or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
Not specifically, Your Honor, but I do believe that the defendant was on parole at the time of this offense.
Sir, is that correct?
Yes.
All right.
Yes, Your Honor.
So I asked you whether or not you were on probation or parole. So you were on parole.
Yes. Yeah.
I then do have to advise you that your entry of a plea in this case could be a violation of that parole. You understand that?
Yes, Your Honor.
You understand that as such, you could be sent back to do the tail or the remainder of your prison term. You understand that?
Yes, Your Honor.
And understanding that, do you still wish the court to consider accepting your no contest plea in this case?
Yes, Your Honor.
All right. And Mr. Bernstein, are you aware of any other promises, threats, or other inducements?
No, Your Honor.
And correct, Your Honor, I'm not aware of anything else.
All right. And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, sir.
Yes to both, Your Honor.
All right. Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
December 10th at 9 a.m.
just say it again.
December 10th at 9 a.m.
Nothing between those two dates. Then.
No.
December 10th, 2025. You said 9 a.m.
Yes.
9 a.m. That is before me. Bond in this case will continue. Thank you.
Your Honor.
Thank you, Your Honor.
Thank you. You can stop down at my probation department to start the process with them. They're on your left as you go down the hallway.
Okay, thank
All right.
you.
Thank you.
Well,
Discovery due today or not. In minutes, a heated exchange turns into a no contest plea with parole on the line. Then, a landlord-tenant dispute collides with court procedure. 1 judge, 3 crises, 0 hesitation. This is real courtroom pressure, expertly handled.
Ms. Baker, you had indicated, and I just wanted to advise you that you had wished not to have a judgment in the case.
Correct.
Okay, I want you to understand that if I hold your trial and I render a decision, you will have a judgment if it's against you. You understand that?
Yes.
You understand also that if you wanted to speak with counsel, there are ways of working it out where there would not be a judgment on your record.
Yes.
Have you talked to counsel about that?
I have not been able to get in contact with anyone from council.
No. The individual here today.
Yes. Sorry.
Did you talk to her about that
Yes.
scenario?
Yes.
Did you guys talk about that scenario?
Conditional dismissal with a payment.
But you're not interested in that.
No.
I'm just saying because you had indicated to me that you did not want a judgment. And you understand that if I render a decision, it's not going to be with the payment plan if it's against you.
I have a question. With that being in mind, would I have time? Would I have time to pay? If it was rendered against-
Ma'am, the best I can advise you, because I want you to fully think about it, is that you might have time to pay, but any remedies for collection of that, including like garnishment, other things.
I still want to see.
So you're going to interrupt me again?
Sorry.
I was answering your question, but it seems you want to just proceed it. You can do what you want to do. I don't. Let me do a couple of things. Okay, go ahead. I gotta figure out this one. What is that set for? No, the other one.
Oh, next week.
Court does call the case of Anderson versus Lyman. State your names.
Lori Anderson.
All right. We're here today for a decision on this case, but I'm a bit confused about one thing. Ms. Anderson, you filed a new case for non-payment?
Yes, that was just to make sure for,
Make sure of what?
she hasn't paid, September, October, or, rent, so. I was told to file a
Did
7-day.
you put September in escrow?
No, I have not.
When are you gonna do that?
This Friday.
This Friday. And then what about October?
I'm gonna get that in as soon as possible as well. I don't have a date.
So
I thought I was supposed to.
what?
Sorry.
What did you say?
I thought I was supposed to since she was late for rent for 3 months.
Well, if I render a decision on this case, something's got to be done with that one because this is a non-payment also.
Yeah, it is, sir. I'm sorry.
When is that set for?
November 7th.
That's the 8:30 hearing.
Yes.
My date after that is in what?
It's included.
No, no, this is for Tuesday. So here's what I'm gonna do. That case, have you been served on that case, ma'am? A new one
So, yes.
to come to court on the 7th?
Yes.
All right. I don't know why that was done, but it's now caused a bit of confusion procedure. Yes.
I thought I was supposed to when it was late. I'm sorry if I made a mistake, but
Well, there's an escrow order that's in this case. I mean, and you went through a whole hearing on this case.
yeah.
And I'm gonna render a decision, but that other case is outstanding. So what I'm gonna do is I'm gonna let that proceed on the 7th. I'm gonna adjourn this case to, my decision on this case to November 18th to allow that case to catch up because I don't want a stray case out there. You have the option if you want to, I'm still adjourning this one out to that date, but you do have the option that what you can do is you can dismiss that other case because I don't know what you would get out of that case that you wouldn't get in this case.
Can I dismiss the?
I don't have it in front of me. I don't even know where you filed it.
Can I dismiss this case and just go with this one on the 7th? Since it's for non-payment of rent? That's what I prefer to do.
I'm not gonna relitigate this whole case.
I just
That's
want,
what you wanna do.
no, I just want to do it for non-payment of rent. I can dismiss the first case and just,
Well, she's got some counterclaims. You wanna just dismiss this case and just go forth on,
Might as well keep going. We've been here since June, so I just.
oh, I know.
I mean, there's also an outstanding water balance of almost $1,500. So I would just rather cancel this case since I'm the plaintiff and then just go with the 7th.
The water bill she mentioned, she took the water bill out of my name and paid it in full.
It was due on the 6th and they said it would go on my tax bills if I didn't pay
I
it.
don't
So
know
I
why
paid
I'm
it.
talking about a water bill at this point.
Sir,
What do you want to do? Because you've got this thing all over the place.
I'm going to withdraw this case and just go with the 7th for non-payment of rent. She's 3 months behind right now. And the water bills,
How can she be 3 months behind? She's,
September, October, and then it'll be November, and then the water bill of $1,500. So it's well over, she owes a total of $15,000, a little over 15, and she has 6,600 in escrow. So it's getting deeper and deeper. The further we delay it, the bigger the hole gets.
I'm not delaying anything. You keep doing stuff.
Well, I want to withdraw this one and just go for the 7th since I'm the plaintiff on both. For non-payment of rent, that's all I'm concerned.
No, I know. That's why I don't understand the second case.
Well, that's all I want is the.
I mean, you think I'm sitting up here and don't know anything.
Yeah,
I look stupid, but I'm,
no, you're very smart, sir.
oh, I know that.
I would just rather withdraw this case and just go on with the 7th.
You let me know when you're done talking.
Okay, sir. Thank you, sir.
Are you done?
Yeah, I mean, the other attorney
Apparently not. Go ahead.
the other attorney I was working with before suggested that I do that I withdraw this case and just do the 7-day notice. That's what he suggested. He said that would be easier.
Watch the gavel guide the storm. Prosecutors push for video, a defendant risks going back on a parole tail, and a landlord case threatens to derail the docket. When emotions rise, the judge draws the line and keeps justice moving.
You done?
Yes, sir.
Lyman, what would you like to do? So just so that you understand, if she dismisses this case, what I would do is I would pay the escrow over to her, okay, on this case. None of, if you dismissed it, I wouldn't be dismissing any of your claims that you have against her. I wouldn't be dismissing any of them with prejudice. You'd be able to raise them in the other one if that's what you choose to do. But that's up to you. And then you'd have to come back on the 7th and we'll see exactly where we are.
I just feel like we should just keep going because we're starting it.
But
Finish it out.
since I'm the plaintiff, don't I have the right to cancel that one, listening to my counsel?
You should have gotten an attorney before you started.
I
But
know, but that's what he suggested I do. He said,
no, because once she's answered, she has the same right. She can say no.
okay. So if I cancel the one on the 7th, can we just be done with this today? Is that better? I just don't want to keep dragging this on. So if I just kill the one for the 7th and we just,
Ma'am, I can't give you.
well, that's what I want to do.
as to, well, I don't have that case in front of me. It hasn't even been heard. It was filed.
It was just for non-payment of rent, but since you said it overlaps this one, then let's just cancel that one and just do the non-payment of rent on
Here's
this.
what I'm gonna do. You're gonna stop talking,
Okay,
and then I'm gonna do what I was gonna do at the beginning. And that is, I'm gonna let that other case catch up. They're just gonna be together because you elected to file it. Under what reasoning, I'm not even concerned about that. But I'm not gonna have two cases standing out in this situation. So I'm adjourning this case for its decision to November 18th. When we get to the other case on the 7th, I will try to have that case catch up with this case. And then we can just decide everything, unless somebody wants to file something else in the interim. Thank you.
thank you.
What time on 18th?
9.
Are we coming on the 7th as well, sir? Okay. Thank you.
Defense attorney Bennett, a skilled lawyer, crossed the line between zealous advocacy and naked intimidation. His mistake wasn't arguing hard, but letting his frustration escalate into a direct threat. In a place where words are the ultimate currency, he risked everything. The response from the bench was immediate and absolute. The judge didn't just overrule him, he issued a clear warning. Bennett could face a grievance against his license. The atmosphere instantly shattered. Humility replaced defiance. The tough professional facade broke, and Bennett apologized immediately, even offering to self-report his own misconduct to the disciplinary committee. It was a rare admission of failure in a system built on argument. But the lasting lesson, the principle that now echoes in that courthouse, right, wasn't about the lawyer's mistake or his apology. It was the judge's crystal clear reminder to every attorney present. No one is ever going to come into this courtroom and be intimidated by threats to their profession. So that statement is the true foundation of justice. It's the requirement that the system function based on respect, integrity, and responsibility, not on fear or bullying. This was more than just a case. It was the clearest, most urgent lesson in professionalism under pressure you could ever receive.